All right. Tracy, can you hear me?
I can hear you. Good morning.
Good morning. All right. We should go on the record with proceeding 24AL-0496E in the matter of advice letter number 878, filed by Black Hills Colorado Electric LLC to amend the Community Solar Gardens annual and fixed credits to become effective January 1st, 2025. I, Administrative Law Judge Robert Garvey. Today is the 16th of May, 2025, approximately 9 a.m. Proceeding comes on for evidentiary hearing. I will start with entries of appearance. I'll start with the applicant and then go to staff and then go to the interview. So go right ahead.
Morning, Your Honor, and thanks for your flexibility with scheduling this. My name is Greg Sopkin, and I am representing Black Hills Colorado Electric. Our sole witness today, Dan Ahrens, is also called into this.
Good morning, Mr. Shopkins, and thank you for saying Ahrens because I was getting all set to call him Mr. Ahrens. So appreciate that. All right, Ed for staff.
Good morning, Jennifer Hayden and Josh Horman, Assistant Attorneys General with the Department of Law, representing PUC trial staff. With us today is staff witness, Dr. Nick Bongiardina.
Good morning to all three of you.
Good morning, Your Honor. Ellen Howard Coots are here on behalf of three parties, the Colorado Solar and Storage Association, the Solar Energy Industries Association, and the Coalition for Community Solar Access. We are calling ourselves the joint parties in this proceeding. Hopefully that makes things easier. Nice to
Yeah.
see
Yeah, I just said the interveners. I didn't want to go through the
That's
whole
fine.
thing either. Made it much easier for me. Okay, I'm going to read what I believe I still need to read real quickly, and I'll do an abbreviated version of this. We are conducting this hearing utilizing electronic pre-filed exhibits. A spreadsheet has been prepared to navigate documents pre-filed in the Commission's administrative record. The spreadsheet indicates the latest versions filed at this point in time. The spreadsheet has been marked in Hearing Exhibit 500. It reflects the date of the latest filed version as it appears in the Commission's administrative record. A title reference for hearing exhibits that will be utilized during the hearing, and the titles of hearing exhibit as reflected in Commission's records. I'll give this to you later, Tracy. Any item listed in the spreadsheet is admitted, and evidence will be admitted by administrative notice based upon the existing filing referenced in the Commission's file. As such, those portions of the administrative record would become part of the evidentiary record. The fact being administratively noticed is that the electronic pre-filed copy in the administrative record is the content of the otherwise admissible exhibit being admitted. It's admitted. It's 500. Does anyone have any objection to Exhibit 500? Hearing none, it shall be. Go ahead, Mr. Chairman.
Your Honor, this morning I was prepared to say the same thing, which is requesting that Hearing Exhibit 500 showing all the pre-filed testimonies and exhibits in this case should be admitted. But we did receive a email last night from the joint parties through Ms. Cootser, and I believe she has some corrections to some of the exhibits.
Okay, for the time being, we'll admit 500 for at least the ones that are in there, and then any corrections we'll get through with Ms. Crane. So 500 shall be admitted for its purposes right now. Okay, any preliminary matters, any stipulations to exhibits?
Your Honor, if I might, to address Mr. Sopkin's comment, we are prepared to introduce some corrections when Mr. Elder takes the stand. Those corrections are uploaded into our box.com folder. If you'd like to proceed another way, happy to do that, but that was my plan to address those corrections.
That's fine with me. That was just fine with me.
Great.
I do have one issue with that, Your Honor, which is it is possible, because Mr. Ahrens goes first as a witness, that one of the changed exhibits may need to be used. And so if those are only going to come in through Mr. Elder, that could present an issue if we're referring to an exhibit that needs to be changed.
Well, I guess my first question is, how major are the changes? Are these grammatical changes, or are these major changes in the testimony?
There was a an error in the arithmetic that Mr. Elder put forward. I did explain this in email to council last night. That email is also on box.com if the commission desires. It did have corrections that flowed through to a spreadsheet that was attached to his testimony. We're prepared to walk through exactly what that is. For Mr. Sopkin's sake, I don't plan to ask Mr. Ahrens any questions about calculations in his his rebuttal testimony. So I don't see a need to introduce those corrections early now based on the cross-examination I have prepared. And I think I'm the only party cross-examining Mr. Ahrens, but again, happy to proceed however you all would like to introduce these corrections into the record.
How does that work for you, Mr. Sopkin?
Yeah, that's fine. We can play it by ear.
Okay, sounds good. Okay, anything else? Any other preliminary matters? Is there any stipulations to the exhibits right now? Or anything like that? I don't know if you don't have anything like that, that's fine. If there's no preliminary matters, we can just move forward. And Mr. Sapp, you can call your first witness.
Your Honor, Black Hills calls Daniel Ahrens to the virtual stand.
All right, Mr. Ahrens, raise your right hand for me. You swear and affirm to tell the whole truth, nothing but the truth under penalty of perjury.
Yes, I do.
All right, Mr. Ahrens, you got anybody in there with you?
I am flying solo.
Okay, all right, anybody comes in there, tell me about it. I will tell you also being recorded and you're gonna also on YouTube. So with that, Mr. Sopkin, you go right ahead.
Mr. Ahrens, please state and spell your name for the record.
My name is Daniel S. Ahrens. Last name is Ahrens.
And by whom are you employed and in what capacity?
I'm employed by Black Hills Services. I am a manager of regulatory.
And did you cause to be filed in this proceeding, hearing exhibit 100, your direct testimony and attachments to that direct testimony?
Yes, I did.
And did you cause to be filed in this proceeding, hearing exhibit 101, which is your rebuttal testimony and attachments to that rebuttal testimony?
That is correct, yes.
And do you have any corrections or changes to your testimony or exhibits?
Not that I'm aware of.
All right. I would tender the witness for cross-examination, Your Honor.
All righty. Ms. Kuchar, go right ahead.
All right. Good morning, Mr. Ahrens. I think we've met outside the hearing room, but for the record, I'm Ellen Kutzer. I'm representing the joint parties in this proceeding. How are you this morning?
I'm doing well. How are you?
I am doing well as well. And I did reserve 30 minutes to speak with you this morning. I anticipate we will not need all of that time. So just wanted to give everyone a heads up about that. So let's start with a few questions about the key remaining issues in this case. Can you and I agree that there are two central issues remaining to be resolved by the commissions in this proceeding?
I agree with you on that.
And one of these issues is whether a utility's fixed CSG tariff needs to include a bill credit for vintage years prior to 2025. Do you agree?
Yes.
And the other issue is whether a utility's tariff a fixed bill credit tariff needs to consider an adjustment mechanism to the value of that bill credit to subscribers over time. Do you agree?
Yes.
All right. And would you also agree that the fixed bill credit requirements are driven by the language of House Bill 23-1137, as well as the Commission's electric rules implementing House Bill 1137?
Yes.
And can you and I also agree that the Commission order adopting the rules implementing 1137 is instructive as to how the Commission envisioned the fixed bill credit methodology should be adopted?
I agree with you. Yes.
Couple more level setting questions. In this proceeding, has Black Hills calculated a fixed CSG bill credit for any vintage year other than 2025?
No.
So, if the Commission in this case determines that prior year vintages of fixed bill credits are required, will Black Hills filed tariff be out of compliance with that decision?
Yes.
And so you'd need to file an updated tariff, correct?
That's correct.
Okay. And has Black Hills considered or applied an adjustment mechanism to the 2025 CSG fixed bill credit as it's filed?
We have not.
So again, if the commission decides an adjustment mechanism is required, the Black Hills tariff will be out of compliance with that decision.
Correct.
Okay, let's get into the commission decision adopting the rules that implement HB 23-1137. Could I please turn to what's been pre-marked in the joint parties box.com as hearing exhibit 301? And I'd like to go to page 7, paragraph 21. Mr. Aaron, this is everyone's least favorite exercise, but I'm gonna read this into the record. Can you let me know if I did anything wrong in my reading? So here at paragraph 21, the commission states, and let me level set. So do you agree with me that this is the commission decision adopting the CSG rules for fixed bill credits?
Yes.
Okay, great. So here at paragraph 21, the commission says the intended design of the utility tariff is the primary way the rules proposed in this NOPR address the requirements of 40-2-127 5B Roman 2E CRS that the rules adopted by this commission, quote, consider the change of value to community solar garden customers of the fixed bill credit over time through rate adjustments or other mechanisms, end quote. As base rates, rate adjustments, and the utilities costs for delivery, integration, and administration of CSGs change over time, such fluctuations are addressed each year through the annual tariff filing process. Mr. Aaron, did I read that correctly?
I believe you did.
Great. I'm doing well on a Friday morning. So do you agree with me that here in this decision, the commission is acknowledging that it has a statutory requirement to, quote, consider the change of value to the community solar garden customers of the fixed bill credit over time through rate adjustments or other mechanisms, end quote?
I believe that the statute did direct the commission to make those considerations in the rulemaking process. Yes.
Great. And so based on that last sentence, the commission is also saying that is the annual tariff filing where the commission will consider the change in value of the fixed bill credit. And that's this proceeding, correct?
It is.
Great. Can we move down to page 11, paragraph 43? I'm going to do another reading exercise, so let me know if I get anything wrong, Mr. Aarons. So here in this paragraph, the commission states, we decline to adopt the proposed addition to Rule 3881. We conclude that an additional series of proceedings is unnecessary since the tariff filing approach, as explained above, will provide an opportunity each year for the utility or a protesting party such as COSACIA to pursue a change in the applicable bill credits. 4 years may also be too long of an interval for adjustments. Retail electricity rates and riders change in scope and levels much more frequently. Did I get that correct?
You did.
So again, the commission reiterates here in this paragraph that is the tariff filing proceeding where parties have an ability to address changes to fixed bill credit rates, correct?
Correct.
Great. So Mr. Aarons, based on what I just read, there are 2 instances in the commission order adopting the rules for fixed bill credits for CSGs where it specifies that this proceeding, this tariff proceeding, is the one in which the commission should consider how it should address adjustments to the bill credit mechanism, correct?
Yes.
Great. Okay, let's talk a little bit about that bill credit adjustment mechanism. Mr. Aarons, would you agree with me generally that Colorado is in an inflationary environment today?
I believe that's true.
So can we also agree that in an inflationary environment, a dollar will purchase fewer goods and services in the future than it does in the current day?
Depending on what that good and service is, yes.
So another way to say that is buying power decreases over time in an inflationary environment, correct?
Depending on the goods and services that are being purchased, yes.
Can we agree that a consumer price index is one index that can help to quantify inflationary forces between 2 points in time?
Depending on what it's being applied to, what goods and
Great. Can
services,
we,
that is correct.
oh, I'm so sorry, I cut you off. There was a little delay in the Zoom. Is that still happening for others?
I missed a little bit right at the end of Mr. Aaron's, what he said. I could just cut out for a second.
Was my answer cut off a little bit?
A little bit right near the end.
Repeat it if you'd like.
Yeah, please. If you would.
Okay, sure thing. I was pointing out that, yes, I agree with her that depending on goods and services, that CPI is a inflationary, representative of inflationary factor.
Great. He is cutting in and out for me. I'm going to go slow, and if it happens, we'll deal with it, I guess. Okay, so if we could take this exhibit down, please, and turn to Mr. Aaron's direct testimony. I believe that's hearing exhibit 100, page 14. Would be great. Thank you. And Mr. Aaron's, I'd like to look at lines 12 and 13. And you see here, the consumer price index has very little relationship with utility rates. Is that your testimony here?
It is.
Now, just to level set, at this point in this proceeding, in this question and answer, this was your direct case, correct?
Correct.
And the joint parties had not yet filed their answer testimony at this point in time when this testimony was filed, correct?
That is correct, yes.
So you, in filing this, you were anticipating that the joint parties would be suggesting a consumer price index adjustment mechanism in the case, correct?
That was a possibility.
And that's partly why you decided to raise it in your direct testimony here, correct?
That is correct.
Okay, great. So if we could go to page 15, line 1, just the next page. You say indices, on the other hand, starting at line 1, indices, on the other hand, have no direct relationship to utility fixed costs, which is what the credit is intended to provide. Mr. Aarons, is that still your position today?
Yes, it is.
Okay. Can we please turn to what's been pre-marked as hearing exhibit 301? I may have this reference wrong. I think it's 302, excuse me. Can we turn to what that's been pre-marked in our box.com? Thank you. Mr. Aarons, based on the cover page here, do you recognize this to be Black Hills Electric Rate Book?
Yes.
Okay, could we please turn to page 175? And can you and I also agree that this is the portion of the rate book that addresses the Energy Assistant System Benefit Charge?
Yes.
And can we scroll down a little bit and look at the adopted date for this particular part of the rate book? So we see here that it was adopted by Advice Letter 874. It went into effect October 1st, 2024, correct?
Correct.
Do you have any reason to dispute that this is the current version of the Black Hills Energy Assistance System Benefit Charge and Schedule?
I believe it. I have no reason to doubt that it's not the most
Great.
correct.
I'd like to move to admit hearing exhibit 302.
And an objection to 302.
One second, Your Honor. No objections.
Okay, 302 shall be amended. Hey, Mr. Kutzer, you didn't move for a 301. I'll just tell you that right now before I forget to ask it. I don't know if you want to move to admit that or if you want to take administrative notice of that since it is a commission decision.
Appreciate that, Judge Garvey. I realize in prepping for hearing that's actually already in the record as an attachment to Black Hills testimony. But if it's cleaner, I'd move to take administrative notice of that one.
Okay, while we do that.
Okay, great. Sorry for that. That's my fault for not preparing properly.
Sorry. What's
Um,
the decision number on that real quickly? Just so.
The attachment number is, give me one moment. I believe it's hearing exhibit 100, attachment DSA 1.
Okay, great. Okay, thanks. Go ahead.
Alrighty, so we're talking about the rate book. Let me get back to my proper point in the notes. Okay, Mr. Ahrens, just to level set here, can you explain to me as the Director of Regulatory what the Energy Assistance System Benefit Charge is?
Just to make sure that we're correct. I'm a manager, not a director, but I appreciate the thought. This is a charge for energy assistance that is outside of the company. The commission, I think legislature directed us to start collecting funds for this program, and it increases on an annual basis based on the CPI.
Well, you anticipated my next question. So there in the highlighted language, we see that over time, these charges to customers are adjusted over time based on the consumer price index, correct?
The amount that's collected for the system benefit does increase by based on the CPI, yes.
Now, is that EABSC rider being adjusted to account for the change in the value of the dollar over time?
It is.
Great. And are you aware that the Commission applies CPI in a variety of different regulatory contexts?
I can think of one other. That would be the customer deposit rate. I'm not too sure if there's any others that come to my mind, but it's possible.
Okay. Any reason to dispute that the Commission's electric rules, 3205B2, apply a CPI adjustment to the threshold at which construction or expansion of a generation facility is considered to be in the ordinary course of business?
I have no reason to doubt what you're saying is incorrect, or I have no reason to think that it is not correct.
Okay, great. And any reason to dispute that the Commission's towing rule 6511 also applies the consumer price index to adjust the maximum rates and charges that towing carriers may assess in its towing rules?
I'm not familiar with the requirements for towing.
Great. Okay. No problem. But point of this being is that the Colorado Commission has used CPI as an adjustment mechanism across a variety of different regulatory contexts. Agree?
I agree that there are. I'm not too sure whether I would agree that it would be appropriate for a fixed bill credit.
All right. Understand that. That's all the questions I have for you, Mr. Ahrens. Thank you for your time this morning.
Thank you.
All right, Mr. Ahrens, I don't have any questions for you. I'm the only other one that could have any questions for you. So I'm set. Mr. Sapkin, any redirect?
Yes, Your Honor. Thank you. Mr. Ahrens, you were asked a number of questions from Ms. Kutzer. In the beginning, she identified two issues that are remaining in this proceeding. One is whether there should be a fixed credit adjustment mechanism, and the other is whether the fixed CSG credit should include vintage years prior to 2025. You recall that?
Yes, I do.
And then just real quickly, with regard to the whether the fixed CSG bill credit should include vintage years prior to 2025, is Black Hills claiming that CSG projects that have a vintage prior to 2025 should not be able to receive any CSG fixed bill credit?
No, that's not my my recommendation. My recommendation is that we shouldn't have to go back to include in our tariff vintage credits that go before 2025. I know, as in the testimony of the joint parties, There are some CSGs that have participated in the process that have yet to go commercial. We believe that those CSGs still have the opportunity to select the fixed bill credit, but it should be based on the 2025 vintage.
Okay, and very quickly, in your rebuttal testimony, which is hearing exhibit 101, do you identify what the fixed CSG bill credit should be for 2025 in at your page 8 table DSA 2? If we could pull that up. Page 8. Okay, Mr.
Yes.
I'd like to jump in here, Mr. Sopkin. I asked him about the filed version, and this is the rebuttal case. So to my knowledge, this is not a new proposal from Black Hills. So it'd be helpful to lay a foundation of why this is related to the cross-examination I've just performed.
Sure. Ms. Kutzer identified this as a remaining issue. And I'm almost done with this portion of my redirect, but it is simply to show that it should not be a remaining issue because, as I will lead into, Mr. Ahrens is going to identify that the fixed bill credit available for these vintage years before 2025 are in fact higher than the vintage years themselves. So there should be no remaining issue here. That's the relevance.
Okay.
And again, I've got maybe 2 questions.
Is there a question pending to me?
I don't know if there's a ruling or if I can go ahead.
No, go ahead. I was going to say, I got from Ms. Kutzer that she was no longer, I wasn't quite sure if that was an objection or just wanting a foundation. And I think you laid the foundation, and it sounds like Ms. Kutzer was satisfied with that foundational lay.
Mr. Ahrens, first in this chart, can you simply identify what the blue shading means?
Yes, I can. That is what we had provided as the annual bill credit for each year that's listed on the left-hand column. The numbers in blue are what the historic numbers have been. So based on what the company has proposed is that the fixed bill credit will equal the annual bill credit at that particular year. That if we were to use that same methodology, and if we did go back in time, the fixed bill credit for 2023 would be that 1197.
Okay, and that's the same with the other vintage years as well. I forget exactly what years the joint parties have mentioned, but it's previous years. In each case for the previous years, the vintage CSG fixed credit amount is lower than the amount that would be available for the 2025 CSG fixed bill credit. Is that correct?
That is correct.
And is that number for the 2025 fixed bill credit, would that be the 0.1242? Or is that for 2024?
I think that's 20. I think that that is what we are proposing in this particular case. I think that it's lagged 1 year.
Okay. All right, and just so we all understand what this chart means, last question on this: what are the numbers in pink shading?
The pink shading is if we were to take the annual number and inflate it for each year, what the inflation adjusted fixed bill credit would be. That's the numbers in purple. or I'm sorry, pink. So for example, if you're looking at 2016, the annual bill credit was 11,011, and that if we were to inflate that number by the CPI by 2024, that amount would have been the 1450.
All right, and in terms of the CPIU that you're referring to there, if we can go to page 7, are these the CPI numbers that you used for that?
Your Honor, I would like to object at this point. I simply asked the witness if there was a remaining dispute. He confirmed that there was a remaining dispute. This has now moved into an opportunity to present direct testimony on what's in, his rebuttal case, which I didn't ask any questions of. So I object to this line of questions.
Mr. Stockton?
I think the door is opened, Your Honor, by the fact that much of Ms. Kutzer's cross-examination of Mr. Ahrens is the propriety of applying the CPI. And so we need to know exactly what that means.
Yeah, I'm gonna allow it in. I mean, he brought up the CPI whether it should be used. That this is an issue in the case, and if their statement is that this was resolved with this testimony here, then I think it's relevant to come in.
Mr. Ahrens, do you remember the question?
Could you repeat it, please?
Sure. Does table DSA 1 show the CPI-U data that the joint parties are proposing be applied to the fixed CSG bill credit every year?
Yes.
All right, thank you. And we can take this down. And as I recall, hearing exhibit 302, which is the company's tariff, was admitted. I would ask that hearing exhibit 102 be pulled up, which is also part of the company's tariffs. Mr. Ahrens, do you recognize the document before you?
I do recognize that.
Can you describe what it is?
It is our tariff for the Renewable Energy Standard Adjustment charge.
All right, and the first sentence of that is the charge for electric service calculated on a company's total electric rate shall be increased by 1.50%. Is that what the company's current renewable energy standard adjustment is?
Yes, this tariff took effect January 1st, 2025.
Okay, and what is the renewable energy standard adjustment, or RESA, cap?
It is 2%.
And so has the company elected to lower its RESA amount below 2%?
Yes, it has.
Okay, we can take this down. Mr. Ahrens, how are CSG credits paid for?
CSG credits are paid through the RESA.
And can you elaborate on that?
Yes.
Go ahead.
Yeah. The credits are calculated using a methodology called the TAR. It's looks at the total revenue by class, and then from that there are certain deductions which account for those components that the commission has approved that CSG customers should pay for. Customer charge, T&D, and a couple of riders. That credit that is given to the customers is then recovered through the RISA.
Okay, and this Kutzer asked you a number of questions about how the commission recognizes a CPI index in certain contexts outside of CSG bill credits. Do you recall those questions?
I do.
Okay, well, let's talk about what CSG bill credits are attempting to do. If we turn to your direct testimony, Exhibit 100, at page 7. Okay, and if we scroll down just a couple lines here, that's good. You were just talking about the TAR and how the TAR is calculated. Can you please describe what the intent of the TAR is in terms of how to set the CSG bill credit?
Yeah. Essentially, the TAR really identifies a credit that starts with the total revenues by class, but then makes adjustments for those components which the commission has identified that the CSG customer should pay for. And those are both tariffed base rates as well as certain riders. So that's what that credit is really designed to do, is to allow the CSG customer not to pay for things such as generation or fuel and purchase power costs, but just those costs that the commission determined that the CSG customer should pay for.
And Mr. Ahrens, I'm going to interrupt you for 1 second. And just for the record, I want stated that what the TAR stands for, if you could tell me real quick.
Sure, it's the total aggregate retail rates.
Thank you.
All right, Mr. Ahrens, you just said the purpose of the credit is so that CSG customers do not have to pay for certain things. I believe you identified generation and fuel and purchased power cost. And is that because they are essentially buying the generation component from the CSG provider?
That is correct.
All right. And so in terms of how to properly calculate that avoided cost, in other words, what the credit should be, what should the commission be looking at to determine what's appropriate for that credit?
And that TAR calculation that we do every year is updating what that credit should be what the credit is based on both what the current base rates and what the current riders are, so that the credit that is updated in the annual calculation reflects what the current costs are for those components that are being avoided.
All right, so it's a cost-based exercise. You just say to determine what those proper avoided costs are, and determining the credit. What is the problem of using CPI-U toward that end?
At that point, you're departing from what the actual retail rates are. I have a table that's in my testimony that we were showing earlier that the inflation adjusted annual fixed bill credits are much higher than what the updated annual numbers are. So if you're giving a larger credit, then you're departing from what the causation really is. You're showing that these customers are getting a credit that's above what they save or the service that they're taking not from the utility but from the CSG. And as a result, those costs get flow through the RISA, and the other customers have to pay for that.
All right, and if we can go back to that rebuttal testimony on page 8 to see that chart again. All right, and this table DSA shows, again, in the blue shading, what the company has computed using its cost-based methodology to determine what the fixed bill credit should be going forward, as well as the vintage bill credits going back to 2016. Is that accurate?
That is accurate.
And then turning to page 7 of this document, this shows the percent changes again for CPI U. Are these amounts in this table DSA 1 a higher percentage change than the blue shading shown on the next page for each of those fixed bill credits?
Yes.
And then going to the next page again. And the difference is shown in the pink shading as to what application of the CPI-U would result if the commission adopted that approach for the fixed bill credit. Is that accurate?
That is accurate.
And what is the problem if the commission does adopt a methodology that is not reflective of the actual avoided costs that should be in the CSG credit? What is the consequence of that to other customers that do not use the CSG program?
It just means that additional costs will go into the RISA. At some point in time, we were going to have to increase the RISA charge from the current 1.5%, and we can increase that up to 2%, which is the cap. But to the extent that if there are credits that are greater than what the cost savings really are, it's going to cause other customers to pay that difference.
Okay. And are you saying there would then be a cross subsidization?
Your Honor, I'm gonna object. I think we've now gone very well beyond the scope of any of the cross-examination questions. There's not been any questions about the rebuttal testimony, Black Hill's approach, certainly no questions about cross-subsidization. This is well beyond the scope of the questions I asked.
I think we're going over the same ground to do Mr. Sullivan, so I'm not saying that.
Thank you. Is Black Hills blanketly against any adjustment mechanism from being applied in this proceeding?
No.
And if we keep on the rebuttal testimony and go to, I believe it's page 10. No, I'm sorry, page 9. Going to the last question on this page. In your testimony here, Mr. Ahrens, you identify another proceeding 24AL-0479E, which is the Public Service Company of Colorado CSG credit proceeding. And you indicate in your testimony that you read staff's cross-answer testimony filed in that case, which is which proposes a fixed bill credit based on a rolling average of previous 5-year annual credits. Do you see that?
Your Honor, I'm going to object again. This testimony is not yet in the record in this proceeding. If Mr. Sopkin asked the witness about staff's cross-answer testimony that is on the record, I don't see a reason why he can't do that. But as of now, it's not been moved to be introduced, and it's inappropriate to ask a series of questions on this record about something that has no foundation yet.
And I'm fine with moving directly to that question, Your Honor.
Go ahead.
Mr. Ahrens, you've read staff's cross-answer testimony that was filed in this proceeding. Is that true?
That is true.
And now that you have read that testimony, is the company, if the commission decides that a fixed bill credit adjustment should be made in this proceeding, is Black Hills okay with staff's approach with regard to that?
We would be amenable to using staff's approach, yes.
Okay. Think I'm done, Your Honor, if I could just look at my notes for a minute.
Sure. Well, I tell you what, while you look at your notes, I'm going to ask Mr. Ahern. I've changed my mind. That's always the great thing when you're the judge. I can change your mind. I'm going to ask you real quickly, Mr. Ahrens, one question.
Sure.
Do you think that Black Hills is required to make an adjustment that Mr. Sopkin been talking about?
I do not.
Okay.
And I'll ask a follow-up question. Why not?
I believe that the statute directed that the commission should consider an adjustment in the rulemaking process. When they did the rulemaking process, it appears they declined to include that. But I think they did, as Ms. Kurtz had pointed out during her cross-examination, open the door that these proceedings are an appropriate place to consider a fixed adjustment. But I don't think there's any requirement that the commission has to adopt one, nor do I believe one makes sense. But if there is to be an adjustment, I agree that staff's methodology that still relies on the TAR, which is the actual base rate revenue or base rates and riders, is appropriate methodology because it's still cost-based.
And did the commission's decision adopting rules with regard to HB 23-1137 require utilities to file an adjustment mechanism with their tariff?
No.
All right. Those are all the questions I have, Your Honor.
All right, Mr. Ahrens, thank you very much for your testimony this morning. I truly do appreciate it.
Thank you.
As far as I know, you can be on your way. All right, that goes to staff next. Mr. Horman?
Good morning, and thank you, Your Honor. Staff calls Mr. Bungiardina.
Hi, so Dr. Bongiardina, I'm a Chicago native, so I can't mess up your last name. Please raise your right hand. Repeat after. Do you swear to affirm, tell the whole truth, nothing but the truth, and a penalty of perjury?
I do.
All right. All right, Mr. Horman, you go ahead.
Thank you. Good morning. Could you please state and spell your name for the record?
Yes, my name is Dr. Nick Bongiardina. That's Nick. Last name Bongiardina.
And by whom are you employed and in what capacity?
I'm employed by the Colorado Public Utilities Commission as an analyst in the engineering section.
And did you cause to be filed in this proceeding what has been marked as hearing exhibit 400?
Yes.
And if I asked you those same questions today, would your answers stay or remain the same?
Yes.
Thank you, Your Honor. The witness is available for cross-examination.
All right. And Ms. Kutzer.
Thank you, Your Honor. Good morning, Dr. Bongiardina. I'm going to try to get that correct. Apologies in advance if I mess up a couple times.
Ms. Kutzer, that's what you got to do. You got to have an Italian beef sandwich.
Okay.
Because if you have a Chicago Italian beef sandwich, always what's on it is Giardina. You gotta have this one, Bonji.
Ah, now I see. All right. All right, so Dr. Giardina, we've met outside the hearing room, but for the record, I'm Ellen Howard-Kutzer. I'm counsel for the joint parties. Nice to see you this morning. I'd like to start briefly with a couple questions about your qualifications. Could we pull up hearing exhibit 400 on the last page? And while that's being pulled up, when did you start working at the commission?
I started working at the commission in September of 2024.
And have you testified before the commission in the past?
This is my first time testifying.
Awesome. It's a first time for everyone, so I'll try to be kind. Prior to working at the PUC, I saw, oh goodness, I think it's the page before this. I'm so sorry. Yeah, there we go. So I saw here on your statement of qualifications that you worked at the Colorado legislature. Is that correct?
I did.
What did you do at the legislature?
I was the legislative staffer for a state representative.
And in your time there, were you personally involved in the passage of House Bill 23-1137?
I was not personally involved with that particular bill.
Okay, great. And in your time at the commission starting in 2024, did you advise the commission in proceeding 24R-0133E, which was the rulemaking implementing House Bill 23-1137?
No, I did not.
Okay, great. Just wanted to lay that foundation. We can take this down if desired. So were you here when I asked Mr. Ahrens about the areas of dispute in this case?
Yes, I was.
So we agreed that the two areas of dispute is the vintage of bill credits and the filed tariff, as well as the adjustment methodology for the fixed bill credit over time, correct?
Yes.
Do you also agree that those are the two remaining areas of dispute?
Yes, those are the two areas that we're disputing here.
And can we also agree that the joint parties have not challenged the underlying bill credit methodology for the TAR calculation for the variable bill credits in this case?
That is my understanding, yes.
And likewise, the joint parties are not disputing the TAR calculation associated with the fixed bill credits at this time, correct?
Yes.
Okay, great. Now you're a witness in the Excel case as well, correct?
Yes, that's right.
Do you generally agree with me that the two issues that in dispute in this Black Hills case are the same unresolved issues in the Excel case?
More or less, yes. There's small deviations, but generally
Great.
speaking, yes.
And then with Dr. Bongiardina, as staff for the commission, do you think that it's important for there to be a consistent application of the commission's rules across different regulated utilities?
As a general matter, yes, but there certainly could be reasons that they could end up being different.
Okay, great.
Not that I'm necessarily arguing that here.
Okay, great. Appreciate that answer. Let's start off by discussing the vintage issue. So when I say the term vintage in this context, can you explain what that means to you?
Yes. So to me, the vintage is the year assigned to a fixed credit based on when a given CSG subscriber organization applied for interconnection.
Okay, great. And I'd like to turn to your testimony again. So that's hearing exhibit 400, and please go to page 9. And I'm looking at line 7. Could you just briefly read lines 7 through 10?
Sure. So the question is, what is staff's recommendation for the fixed credit vintage? Answer, staff recommends that the commission approve 2025 as the origination date for the fixed credit vintage as initially filed by the company.
So in this proceeding, it's correct to say that you and staff recommend that the commission adopt Black Hill's recommendation to begin the vintages in 2025, but no prior years, correct?
That's correct.
Okay, could we please take this exhibit down and turn to what's been pre-marked as hearing exhibit 303 in the joint parties box?
Hey, Ms. Cooch, I'll tell you real quickly while that's going up. I don't know, you have an hour here. I realize by 10:30, I'm gonna probably want to take a break. So I don't know if you'll be done then or just look for a time to stop around there.
I'm going to endeavor that I will be. I think I will be, but we'll see.
Okay.
In trouble pulling up hearing exhibit 303. Just another minute to try something else.
Okay. Let me check on my end. It's opening for me for what it's worth. So, Dr. Bongiardina, do you recognize this as your testimony from the Excel CSG bill credit case?
Yes, that looks right to me.
Your Honor, I'd like to move to take administrative notice of this testimony filed in the other proceeding. I can. I'm so sorry.
We've lost Mr. Sopkin.
I haven't. Well, I guess I'd ask what the relevance of the testimony in the public service company case is when we have cross-answer testimony from Mr. Bongiardina in this case.
I'd be happy to lay a further foundation if that would be desired.
Well, I'd say I'm kind of concerned because this is a hearing that hasn't happened yet. I mean, I'm not quite sure where in the universe this is. It's not really in that proceeding yet.
I'll say the purpose here is to demonstrate what Dr. Bongiardina is recommending in that proceeding compared to this proceeding. And so it is directly relevant to his recommendations on the vintage issue across cases.
My problem with this, he actually hasn't done that yet. I mean, it's in the, you know what I mean? It's in the future. This testimony hasn't been admitted into that proceeding. And so I don't know that when that proceeding actually occurs, that his testimony might not change. I mean, I guess you can do it in the realm and I don't, it's taking administrative notice of something that might not actually be an exhibit. It should be, it probably will be, 99% will be, but it isn't yet. And so I have a little issue with it there. I mean, if you want to ask me questions about it, I think you can do that.
Yeah, happy to.
I'd be more comfortable with it that way, honestly.
Okay, happy to do so. Could we please turn to page 9, line 9? So Dr. Bongiardina, could you please read lines 9 through 12?
Yes. So the question is, what is staff's recommendation for the fixed credit vintage? And the answer is that staff recommends limiting the inclusion of the fixed credit vintages to the years 2023 and 2024, because House Bill 23-1137 was enacted in 2023.
So yes or no, is your recommendation for implementation of the bill credit vintages consistent across these two cases?
Your Honor, I'm going to object on relevance here still. The facts and the cases are different. And as you mentioned, this or cross-answer testimony for the Piesco case is premature.
That's a good way to think about it. I have a problem with that because he hasn't really testified to this yet. This hasn't occurred. I realize he's pre-filed this, and I guess you have to. I have no problem if you ask the question and say, "Have you pre-filed testimony?" And in that, did you recommend? Do you recommend at this point in time? Do you recommend it? But it hasn't occurred yet, so it's tricky. That's a tricky thing with in the world of pre-filed testimony.
Let me reframe. Dr. Bongiardina, do you stand by the recommendation you have made in the Public Service Company of Colorado case that the fixed credit vintages should be adopted for years 2023 and 2024 in that case?
So the argument in the two cases is the same. The bill was enacted in 2023. We argue that there wouldn't be a reasonable expectation that a fixed credit would be available before 2023. In this case, the joint parties weren't requesting credits for 2023 and 2024. So just as a practical matter, we didn't see a need to have the company update their tariff to reflect years that the joint parties weren't even asking for in this proceeding.
So I'd like to make a point of correction with the witness, if I might. I believe the witness has misstated the joint parties' request in this proceeding. Isn't it correct that Public Service has agreed to include fixed credit vintages for 2023 and 2024 in the other case?
I don't think I care about what's happened in the other case right now. Mr. Kurtz, if you want to limit the questions here to why you recommend, if there's a difference in the two, why was this recommended in the Black Hills case? I'll take that.
Sure.
Question.
So, Dr. Bongiardino, why did you make a different recommendation in the Black Hills case than you're making in the Public Service case?
So, as I just stated, it was more a practical consideration. There were no fixed credit vintages requested between 2023 and 2025 by the joint parties in this proceeding. And therefore, we didn't have a problem with the way the company filed the tariff, only including 2025. And that was just a distinct set of facts and issues in this case compared to the other one.
Great. I think we'll look at the record later as to the statement to the joint parties proceeding, but we can move on from this point. I would like to move to the fixed bill credit adjustment mechanism, and we can take this exhibit down. So just to level set, do you and I agree that Black Hills didn't include an adjustment mechanism for the fixed bill credits in this proceeding?
Yes.
So if we could pull back up hearing exhibit 400, page 11. And could we look at line 16 of your testimony? And would you mind reading line 16 through the end of the sentence into the record?
Starting at, I'm not an attorney.
Correct.
I am not an attorney, but it is my opinion that that decision number C24-0447 fulfilled the commission's obligation to consider an adjustment mechanism, and it opted not to order one while leaving the door open to consider one in the future.
So I'd like to turn back to what we had been referring to as hearing exhibit 301, but we now know is also already in the record as hearing exhibit, I believe, 101, hearing exhibit 100, attachment 1, whichever is easier to pull up.
DSA 1.
Thank you, Your Honor. And could we go back to paragraph 21, which I believe is on page 7? So again, were you in the room when I was talking with Mr. Ahrens about this paragraph?
Yes, I was.
Do you want to refresh your memory and read that paragraph to yourself?
Paragraph 21, you said, correct?
Correct, that's right.
Okay.
And so do you agree with me that in this paragraph, the commission is stating that is the design of the utilities tariff, this proceeding, which is the correct forum in which the commission can satisfy its statutory obligation to consider the change in value of the CSG bill credit through a rate adjustment mechanism?
Yes, I agree that
Great.
they said the tariff filing could be considered here.
Okay, great. So would you agree with me that based on what the commission is saying in this paragraph, it's the tariff design proceeding, this proceeding, where the adjustment mechanism is to be considered, not the rules?
I would say the decision in that rulemaking proceeding pointed to the tariff filings as a venue to consider.
Great. Okay, I think we can move on. So apologies for the back and forth. I need to pull back up hearing exhibit 400. So as Mr. Sopkin alluded to, you have gone on to propose a bill credit adjustment mechanism for consideration in this proceeding, correct?
Correct.
And that discussion of that begins on page 14, line 5, if that's needed. Would you agree?
Yes.
Okay, great. And so you've provided the testimony here as a part of cross answer testimony. Is that correct?
Yes.
And because this proposal was filed as cross answer testimony, procedurally joint parties have not had an opportunity to respond on the record to staff's proposal, correct?
Correct.
Great. So you and I are discussing this matter for the first time today, correct?
Correct.
And do we agree that litigation of this case began when the joint parties filed their protest of the advice letter on December 10th?
Yes, when that protest was approved by the commission, yes.
Great. And then, we went through the case, both the joint parties and staff filed their interventions in January. You agree with that?
Yes.
And in staff's intervention, which we can pull up if necessary, one of the issues staff indicated that it would address in the case is, quote, whether the filing complies with past commission decisions, including decision number C24-0447, which adopted amended rules pursuant to HB 23-1137. Does that sound correct to you?
Yes, that sounds correct. I have no reason to think you didn't represent that correctly.
Okay, great. Were you aware that the joint parties raised the issue of the fixed bill credit adjustment mechanism in paragraph 7 of their protest filed in the proceeding?
I would have to see the protest in order to confirm that.
We can subject to check. Great.
Okay.
And so can we both agree that staff was aware at the time of the filing of their intervention in this case that the adjustment mechanism applicable to the fixed bill credit was an issue in the case?
I'm going to object, Your Honor, to this line of questioning. It appears to be some effort to argue that staff should have filed this in their answer testimony. If we have to get into mechanics like this, which I don't believe are relevant to this proceeding, we could talk about whether the joint parties had an opportunity to file rebuttal testimony, which the parties actually agreed to.
I'm just kind of curious where you're going with this a little bit. You can file a protest letter. That doesn't mean it's going to be an issue in the case. When testimony comes in, issues quite often go away. So I don't think that matters. I don't think it really matters. I mean, I understand you couldn't file something in response to that. I understand that already. So I'm not quite sure where you're going.
Yeah, I'm happy to close this out, but I would like Dr. Bongiardina to explain why staff chose to introduce this new approach, which is quite complex, as cross-answer testimony rather than answer testimony. So that's
Why
my
is,
last question on this line.
why is that relevant?
It's a pretty complex proposal, which we're now, needing to spend a lot of time to go through, and I'd just like to understand why that decision was made.
Why do I care why that decision was made, though? I mean, I understand why you care. I don't understand
Sure.
why I care.
Okay, if you don't care, then that's all that counts, so I'm happy to move on.
It's there, so I got to deal with it. So,
Okay,
let's
get into it then instead. Let's do that, Dr. Bongiardina. So can we stay here on page 14 and look at line 11 where you talk about the staff mechanism? Could you read into the record the sentence starting at under staff's proposal?
Yes, through the end of the paragraph.
Yes, please. Thank you.
Under staff's proposal, a fixed credit vintage would be static for the first 5 years, starting in the year the CSG applied for interconnection. In the 6th year, the vintage would mature and transition to a 5-year rolling average. From that point on, every vintage that is in its 6th year or later would use the same rolling average.
So I'd like to break that down a little bit. So under the staff approach, the fixed bill credit would be static for the first 5 years, correct?
Correct.
Is static another way to say that the bill credit will not change in value for the first 5 years?
That's correct.
And so do we agree that under this staff method, the method would not consider any change in value during that first 5-year time period?
What I would say is that first 5 years is part of the design of the adjustment mechanism as a whole. It's not designed to be thought of as an independent component of the mechanism that isn't related to what's happening further down the line.
But during those first 5 years, we agree no change in value will occur.
That is correct.
Great. So let's talk a little bit about applicability in this couple sentences you just read. So you say under your approach, the first year the static bill credit would start is when the facility applies for interconnection. Is that correct?
Yes, that's consistent with commission rules.
Okay. So is it typical for a community solar garden, in your experience, to generate bill credits in a year in which it applies for interconnection?
My understanding is that generally the CSG is not in operation during that first year that they apply for interconnection, although if they build it very quickly, they perhaps could be.
Okay, great. Let's see how this recommendation compares to the statute and the rules. Could we please turn to hearing exhibit 304? I'm looking at page 2 of that one. And would you mind reading this? First of all, do you recognize this to be a copy of House Bill 23-1137? We can go to the front page if necessary.
If you wouldn't mind, just so I can verify. Okay, yes.
Great. And could we go to that second page again? And could you please read paragraph C to yourself? Let me know when you're done.
Sorry, it's a long one. Okay.
And I highlighted here kind of the key language. So do we agree that under the language of 1137, the fixed bill credit calculation should be determined at the time the subscriber organization bids capacity into the community solar garden.
Objection, Your Honor, calls for a legal conclusion.
Might I respond?
Okay, that's what I'm saying. Yeah, go ahead.
I think Dr. Bonjardina, sorry, I knew I'd mess that up, has himself put forward interpretation of this statute as well as the commission rules into the record. I think because of that, it's fair game to raise this issue. Moreover, I think he's put forward some testimony about the starting point, and it's relevant as to what the statute says about what that starting point should be.
Like I said, I think each of the pre-filed testimonies that Mr. Ahrens, I think, is the only one who does not have, I'm not an attorney, but somewhere in their testimony. So I'll take it for what it's worth and realizing it's not coming from an attorney and give it the weight that I deem proper. So you go ahead.
Do you mind restating the question?
Sure. So do you agree with me that at least under House Bill 1137, the fixed bill credit calculation should be determined at the time the subscriber organization bids capacity into a community solar garden program?
With the caveat that I'm not an attorney, yes.
And do we also agree that bidding capacity into a community solar garden program is not necessarily the same time at which that facility applies for interconnection?
My understanding is those two things coincide, but if I'm mistaken about that, then that's okay.
Okay, great. Just a couple more here. So are you aware that Senate Bill 24-207 created an open interconnection process for community solar gardens?
I would need to verify that is exactly what that does, but
Okay, great. And assuming that's correct, then would you admit that there may be a disconnect in the time in which a community solar garden applies for interconnection versus the time that it applies for capacity in a CSG program?
yes.
Okay, great. Give me 1 second. I may skip this section. Can we turn please to hearing exhibit 305? While we're doing that, Your Honor, I do think I'm still going to finish by 10:30, so I'll just keep going.
You don't have to. I gotta watch out for Tracy. That's just my deal. We're at least a day ahead of where I figured we'd be. So
And Dr. Bongiardina, do you recognize this based on the cover pages, the commission's electric rules?
Yes, I do.
Great. Could we turn to page 231? And let me come back to this. Can we scroll up to the beginning of the number where it says 3881? That's great. So do you recognize that Rule 3881 is the portion of the electric rules that apply to community solar gardens?
Yes.
Tracy, would you mind going back to page 231 again? Thank you. So Dr. Bongiardina, do you recognize that this is the portion of those CSG rules that apply to the fixed bill credits?
Yes, that's correct.
And can you please read subparagraph B into the record?
Yes. The election of the fixed bill credit must be made before the commercial operation date of the CSG.
So do you and I agree that the commercial operation date of the CSG is different than the date the CSG applies for interconnection?
Yes.
Great. So to tie this all together, the rule requires an election of the fixed bill credit be made before the commercial operation date, correct?
Correct.
But under staff's approach, in the new bill credit methodology, the vintage year is based on the date upon which the facility applies for interconnection, correct?
Yes.
Okay, great. So I'd just like to put forward a couple hypotheticals to see how this disconnect might be a problem. Let's say that a CSG project applies for interconnection in 2025 and then bids capacity into the Inclusive Communities Solar Garden program when that opens in 2026 and reaches commercial operation date in 2027. Now, under the staff approach, would the 2025 vintage apply to the project, or would a different vintage apply to the project?
Based on the staff approach, the fixed vintage that would be available to that subscriber or that CSG developer would be based on that initial bid. And then they would have up until commercial operation to decide if they wanted the fixed or the annual credit option.
I appreciate that, but my question was what vintage year would apply under the staff approach?
If I understood your question correctly, I believe it would be 2025 in that initial application.
So if that's true, how can the project also comply with the statutory requirement that the fixed bill credit calculation be based on the inputs that are in effect at the time in which the subscriber organization applies for capacity, which again, in my hypothetical was 2026.
Let me just think about that for a moment. My understanding of what we're proposing is that initial point of contact where they ask or they reach out to the company to have their CSG be a part of the system is the point at which that fixed credit vintage is determined.
So based on this hypothetical and upon reflection, do you agree with me that staff's proposal is potentially inconsistent with the language of 1137 and may need to be revised?
If there are situations that we need to resolve, that makes sense to me.
Okay, great. Appreciate that. Could we turn back? Actually, this is a new exhibit. Could we turn to hearing exhibit 400, attachment NJB1? And if the executable is available, that might be a little bit easier because the PDF kind of cut things up. So that is the PDF version. I put the executable in the Solar Parties box folder. Could we, I didn't label as a hearing exhibit because I didn't think that was proper since this is in the record through staff. So, Your Honor, what I'm driving at is just pulling up the executable version of this, like PDF spreadsheet.
Yeah, I'm getting an error message. I'm not able to pull up the document because the file path is more than however many characters.
Oh, geez. It comes up for me in box when I click on it.
All right, let me try through the Box website then.
While we're doing that, for Mr. Herman's sake, what's in the jointpartiesbox.com that we're pulling up is what staff shared with us on the 13th. And I'm happy to admit that in the record so you can confirm that it's the correct version, but however you would like to proceed.
Yeah, we have no objection to that. I understand what document you're trying to pull up, and that's fine with us.
And
Okay.
that's with staff's stuff. So it's in the record that way. Correct. We don't have another exhibit. But what I will say, well, we got a minute. 303, 304, and 305 is not, I don't know, have not been, you did not ask for admission of those. I don't know if you want to admit it or not, but
Your Honor, I think 303, wasn't that the other testimony? I thought you had ruled that's not.
okay, and it could be.
That's okay. So that one I assume you're not letting in.
Okay.
304 is just the statute, so really just needed that as a demonstrative for hearing. So I'm happy to move to admit that if necessary, but I don't think it's necessary. Same thing with commission electric rules, just there as a demonstrative.
Okay, that's fine.
Thank you for flagging that. I appreciate it.
Yeah, no, I'll do that. Actually, Mr. Saucon, 102 didn't get any of it, by the way, while I'm thinking of it. We didn't ask for admission of it. But Ms. Kutcher wants to go ahead right now.
All right, great. So Dr. Bongiardina, do you see this spreadsheet? You agree that this is the staff proposal, correct?
Yes.
Okay, great. I'm going to spend some time with column E there and kind of walk through what we're looking at. Actually, I should have said to begin with, on columns C and D, we see actual year, and we see a number of years there, forecasted annual year. So when we look at column D here, is that the applicable calendar year that we're looking at when we're looking at the value of the bill credits moving across from left to right?
I believe so. I'll just say it a slightly different way to make sure we're on the same page. That corresponds to the actual year you're looking at for what the value of the credit for a given vintage year is. So,
and
yeah.
Please keep going.
Yeah, so just to make sure for vintage year 2025, in the actual year 2027, you can see that the value of the credit would be, 0.1126.
And just, I don't spend a lot of days in spreadsheets, thank goodness, just so we get this right. So if I'm looking at column E, 2025, that's the vintage year, correct? 2025?
Yes, going along that row 2, yes.
So if I were to move down in column E, let's say to 2032, under staff's proposal, we see the value of the 2025 vintage in 2032, excuse me. Is that correct?
With one caveat, which is the credit values going forward from 2025 are part of like an illustrative simulation of what future credits could look like. Those aren't an attempt to predict what they would be. The purpose was just to show how this rolling average may work over time, given a potential set of illustrative credit values. But yes, that box would tell you what the credit value would be in that year for that vintage.
So that actually gets to a key question I have here. Staff in this case is proposing a methodology that would be applicable through 2038, correct? That's your proposal?
Again, the future years in this proposal are meant to be illustrative to help demonstrate what the structure of this proposal would look like going forward. It's not an attempt to predict the future.
But to my point, if this approach is adopted, every year moving forward, we would need to update the corresponding calculation under the staff approach, correct?
Correct.
Okay, thank you for explaining that. So let's
And-
walk
and-
through.
I'm
Sorry.
gonna interrupt 1 second, and just so I understand that, so every year, so the 2025 vintage would be updated every year starting in 2030, is that correct? That's what I
Correct.
believe the question was, okay.
Correct, and it would roll forward with any other year that had matured onto the rolling average
So
after
it's,
that as well.
so it stays the same for 5 years, and then starting in 2030, each year it adjusts.
Correct, yes.
Okay.
So ALJ Garvey has anticipated many of my upcoming questions.
I
Let me
cut right
see
to the
here.
chase. I cut right there. I go right there.
So let's just clean that up a little bit. So quick level set. Under the staff methodology, it's correct to say that no adjustment factor is applied to the 2025 vintage year credit in years 2026 to 2029, correct?
That's correct.
Stays at that 0.11260 value for those years, correct?
Correct.
And so in other words, under the staff methodology, the TAR calculation for 2025, well, I should say, let me restate. Under the staff methodology, the TAR calculation minus the charges that are come out of the CSG bill credit will apply consistently for years 2026 to 2029.
That's correct.
So essentially in years 2026 to 2029, it will look identical to the variable bill credit in 2025. Is that correct?
Yes, that's correct.
Okay, great. So then at year 6, things start to adjust, right?
Yes.
So under your table, year 6 corresponds to 2025 vintage, year 6 corresponds to 2030, correct?
That's correct.
And so in that year, we see that the bill credit changes to 11.473, yes?
Yes, again, with the stipulation that the numbers that's based on are an illustrative forecast, not actual credits, because the future has not happened yet.
And then the way that this is working is every year moving forward after year 6, you're taking an average annual bill credit value from the prior 5 years, right?
Yes.
So every year we move forward, we're averaging a different set of 5 years in the past to derive that bill credit, correct?
In the past relative to the current year, in the future relative to the vintage year.
Woo, complex. So under the staff approach, in year 2032 for vintage 2025, does the calculation rely on the 2025 value at all?
It does not rely on the 2025 value.
So a community solar garden subscriber organization that selects the fixed bill credit in 2025 would not know how the 2032 fixed bill credit would be calculated. Isn't that right?
I would argue they know exactly how it would be calculated if this methodology was approved. They would know 4 of the 5 years going into the next rolling average. They would just need to wait for the company to update the tariff with the most recent credit value that would factor into that rolling average.
But my question is not, would that subscriber organization know in 2031 what the 2032 value is? My question is, in 2025, can that subscriber organization understand what the bill credit in 2032 would look like? Because it's going to rely on years that are in the future. We don't know what those look like, correct?
Correct. We don't know what the credits will look like in the future.
So under the staff approach, there's not a lot of predictability for the subscriber organization as to what that value will be in the future. Would you agree?
I wouldn't agree. I would say for the first 5 years, they know what their credit is going to be. And by the time they get to that adjustment, that first year of adjustment, they will know 4 of the 5 years that will go into the new credit calculation. It'll change a little bit depending on what that 5th year ends up being, but they'll have a really good, they'll know exactly what it's going to be for 5 years, and they'll have a really good idea what's going to be in that 6th year.
Is it reasonable for them to expect what the 5-year average is going to look like in 2038? That many years in the future?
No, not that far in the future.
Hey, Mr. Kutzer, we get read 10:35, so.
Yeah, I went over. One last question on this line and then break. Is that all right?
That's fine, no problem.
Okay. So do you agree with me? Two questions. Do you agree with me that a community solar garden is generally a 20-year asset?
Generally speaking, yes.
So under the staff proposal for a 20-year asset, how is this a fixed bill credit methodology at all?
I would say it's fixed insofar as we would know the method by which it would be calculated over time. It's tied to the real system costs. And yeah, to the degree we can predict the future, we can't predict the future with other methods any better than with this one.
All right. Your Honor, I'm ready to take a quick break. I'll be very fast when we come back.
No problem. Okay, we'll take a break. Let's say 10:51. We'll be back then. All right, Tracy, you hear me?
I can hear you.
All right. We shall go back on the record then with proceeding 24AL-0496E. And Dr. Bongiardina, I'll remind you that you're still under oath. And Ms. Kutzer, you may continue.
All right, thank you, Your Honor. So Dr. Bongiardina, just before the break, I believe I heard you admit that the staff methodology in this bill credit calculation will not tie to the first year of the vintage of the bill credit after year 7. Is that correct?
The staff methodology ties the adjustment mechanism to the manner in which the credits are calculated.
Let me reframe my question. So looking at the 2025 vintage year, after year 7, the staff methodology employs a 5-year average to calculate the bill credit in year 7, correct?
Correct.
So you admitted that in that year 7, there's no tie to 2025 anymore because we are now averaging different calendar years, correct?
Correct.
Okay, great. Would you agree with me that the staff method really presents a new method for calculating the underlying bill credit itself?
I wouldn't agree with that, no.
Even though you are using a 5-year average for the first time?
It certainly is a new approach, but it is based on the commission-approved methodology for calculating the credits in distinct years and averaging them together, but all of the relevant system costs are incorporated into that calculation implicitly.
Okay, I'd like to go back to hearing Exhibit 304, which is the statute. And can we go to that second page, that subsection C? Can you read into the record subsection C until the word program, Dr. Bongiardina?
Yes. For a subscriber organization that directs the qualifying retail utility to provide the subscriber organization's subscribers with a fixed bill credit, the net metering credit is calculated by multiplying the subscriber's share of the electricity production from the community solar garden by the qualifying retail utility's total aggregate retail rate as charged to the subscriber at the time the subscriber organization applies for or bids capacity into a utility community solar garden program.
Great, thank you for doing that. Now, does the statute explicitly allow for a fixed bill credit to be calculated by an average of the total aggregated retail rate across multiple years?
I would say the statute doesn't explicitly approve an adjustment mechanism based on any particular approach.
Okay, great. I want to have one last point of clarification based on some earlier testimony, and then we'll close up here. So do you recall when I was asking you about your recommendations being different across the 2 different cases? And you recall that exchange? Okay. And then I thought I heard you say that the reason that your recommendations are different is because the joint solar parties are not asking for vintages before 2025 to be adopted in this case. Did I hear that correctly?
If you did, then I misspoke about it being specifically between 2023 and 2025.
I have available the joint solar parties recommendations. Would it be helpful to bring that up just to clear this point in the record?
Did you ask me or are you asking?
I'd ask him just because it came out as unclear to me, and I just want to make sure that nobody's misstating anyone's testimony, and I'm not misstating what he said. So
Yeah, no, that's fine. That's fine.
Let's pull out hearing exhibit 300, page 15. And then, Dr. Bongiardina, do you see here where it says the joint parties recommend that the commission direct Black Hills Energy to update the advice letter with fixed bill credit vintages for 2018, 2021, and 2022?
Correct, yes.
And just to clear up the record, I'll ask you again, can you explain the difference between your recommendations in the Excel case and this case, so that's really clear?
Yes, absolutely. So in this case, in both cases, staff's position is that before 2023, when the legislation was enacted, there wasn't a reasonable expectation that a CSG developer would have access to a credit before the year that legislation was enacted. In this case, the joint parties were asking to add vintages for 2018, 2021, and 2022. And if I'm not mistaken, correct me if I'm wrong, the joint parties were asking for vintages that included 2023 and 2024, which is after the enactment of the legislation. We didn't have a problem with that in that proceeding, and the company in that proceeding had already offered to update their tariff to include as far back as 2023. So we agreed with the company's tariff filing in that proceeding, and we agree with the company's tariff filing in this proceeding for 2025.
Okay, that's helpful, and I apologize if I jumped down your throat on that one a little bit. I just want to make sure that's clear. That's all the questions I have. Thank you.
So, okay, yeah, come on, it's his first time. It's his first time testifying. Someone's got to jump down his throat a little bit. All right, Dr. Bongiardina, I only have one real question for you. In reading your testimony, it appeared to me it stated more or less staff's position is if you're going to do this, here's what we recommend. Talking about this adjustment.
Yes.
So is staff's recommendation to make this adjustment, or is this staff's recommendation don't make this adjustment?
I would say staff's recommendation is that we weren't required to create one here. We don't think we need to create one here. But if your honor decides that is appropriate, we think our mechanism is more appropriate. That's our position.
So you think I should? Think I should?
I guess the most honest thing I can say is we don't think you have to. I don't think we have a super strong opinion about like whether you need to or not in this proceeding.
Okay, fair enough. All right, Mr. Foreman, any redirect?
Briefly, Your Honor. You were asked about HB 23-1137 Rule 3881. And does under that statute and rule, does the fixed bill credit also have to consider change in value?
Yes.
Could you explain how your adjustment mechanism addresses the fixed portion of that fixed bill credit within the change in value? And if it's helpful, we can pull up the executable again.
Yeah, why don't we? I think it would be helpful to have it up just so everyone has the visual.
So if I could ask the question, could you explain how your adjustment mechanism addresses fixed bill credits while considering change in value?
Yes. So as the company explained, the credit is calculated based on actual system costs. Those system costs change year over year, and therefore the value changes year over year to some extent. In order to create an adjustment mechanism that still kind of maintains the kind of spirit of a fixed credit, which is to have a more stable option than the annual credit that can change a fair amount year over year, we thought it was appropriate to use that same cost-driven methodologies, but average them over a period of time to account for how that value changes over time, but in a way that isn't going to be noisy and fluctuate large amounts year over year.
And going off that, could you explain how your adjustment mechanism works within the graphic portion, what's labeled on the screen as figure NJB-1? And if we could please just scroll over to the right, just to get that graph up. Thank you. Could you describe or explain what's going on with this visual?
Yes, absolutely. So the orange lines represent the credit values over time, and the green lines represent the 5-year average over time. The dashed lines represent the historic values that we actually do know what the values were historically. Looking at the orange line, you can see that we have the dashed line goes up to 2025, where we have the credit value in this year. And then my illustrative forecast that kind of builds in the average rate of growth from the historic period into that forecast is represented there going forward. And then the black dot just kind of helping denote that switch over from the historic credit to the forecasted ones. And then for the 5-year average line, that dashed line represents the forecasted, or what that 5-year average would have been had this mechanism been in place from the start, to give us an idea of what this would have looked like if such a mechanism had existed. And then moving forward from there to see how that 5-year average will, or how well that 5-year average really steadies out the fluctuations in the annual credit over time.
And when you say noisy, you're referring to the fluctuations. Can you point to the graph or point on where the graph you see those, the noise or fluctuations?
Yes, and apologies for using a very engineering-y term for noisy there. Yeah, so I think a good example is going from the year 2024 to 2025. There's a fairly large decrease in the credit calculation from 2024 to 2025, and you can see that 5-year average, had it been in place, smooths that out, but it still tracks the actual values of the credits over time.
Thank you. I have no further questions. You can take the executable down. Thank you.
All right, Dr. Bongiardino, you are all done there. Congratulations on completing your first testimony. I look forward to seeing you many times in the future. Hopefully this wasn't too painful for you.
Thank you very much.
You are free to go on your way. All right, Ms. Kutcher, it is your time for a witness.
Thank you, Your Honor. The joint parties would like to call Blake Elder to the stand.
Mr. Elder, if you raise your right hand for me, you swear affirm to tell the whole truth, nothing but the truth, under penalty of perjury.
Yes, I do.
All right, go right ahead.
Mr. Elder, can you please state and spell your name for the record?
My name is Blake Elder. That is BLAKEELDER.
And by whom are you employed and in what capacity?
So I'm currently employed as the Senior Regulatory Policy Manager at the Coalition for Community Solar Access, or CCSA.
And have you caused to be filed what has been pre-marked as Hearing Exhibit 300 and its attachments?
Yes, I have.
And do you have corrections to the pre-filed testimony and attachments?
I do, yes.
How would the answers in your testimony change today if they were asked for you again for the first time today? Or tell me about the corrections. That was a bad question. Tell me about those corrections.
So in preparing for the hearing and going through my testimony, I discovered that there was an error in one of the calculations that was included on, I believe it's page 23 of my answer testimony.
And could we go ahead and pull up the inbox.com what's been pre-marked as the corrected version of Hearing Exhibit 300? If we could go to line 20, page 23, excuse me. Mr. Elder, please feel free to continue.
Sure. So line 13 here, what we were attempting to do is to calculate a percent change in CPI between two periods. What we call first is the current year, which is associated with the year that the utilities advice letter filing, setting forth the vintages for the next calendar year, and the CPI of the fixed credit vintage year. And the way that this calculation should have been written in testimony is to have the absolute change, or the difference between the CPI of the current year subtracting the CPI of the vintage year divided by the vintage year CPI. Instead, what we had listed here is dividing by CPI of the current year. So ultimately, what the result of this is it's not calculating what we commonly refer to as a percent change. It's calculating a different value based upon a change to a new value, in this case, the current year.
And Mr.
So
Elder, I'm sorry, keep going.
I was just going to say, in order to correct that, what we've made a simple change to the reference in the denominator, again, from the CPI of the current year to the CPI of the vintage year.
And Mr. Elder, did this change result in corresponding changes to attachments to your testimony?
Yes. So hearing exhibit 300 attachment BWE3 includes the results from these calculations, and this error flowed through to that output.
Could we please pull up in the box.com the PDF redline version of BWE-03? And while we're doing that, Mr. Elder, is it possible to make redline changes in an Excel spreadsheet?
Unfortunately, it's not. To my knowledge.
And so to note this change, did you create two tables in this redline version to show the difference in the prior math versus the updated math?
That's correct.
Okay, great. And could we please go to page 4? Mr. Elder, would you please continue and walk us through these changes?
Sure. And is it possible at all to zoom in a little bit so we can see some of the numbers here? Yeah, that should be okay. So the set of 3 tables on the top with the red X's is the previous erroneous results. And then the 3 tables on the bottom half of this page reflect the corrected values. And so overall, I guess just to be clear, all of the numerical contents of the cells in the top tables were incorrect and have been recalculated in the bottom. So if we take, for example, the bottommost table reflecting the 2022 vintage, the easiest way to kind of see what has changed here is to look in the far right column at the percent change. So you can see that previously the percent change in the 2022 vintage from years 24 to 25 was a 2.72% change. And then down at the very bottom cell on the lower right, you can see that has increased slightly to 3.22%. So the result of the error kind of across the board is a result, or the correction rather, across the board is slightly higher values for each vintage over the years.
And Mr. Elder, in light of this correction, do you stand by the core recommendations in your testimony?
I do, yes. This was a mathematical arithmetic error, and it doesn't impact the ultimate integrity of using CPI as an adjustment mechanism for the fixed bill credit.
Your Honor, in light of this, I'd like to move to admit the corrected version of hearing exhibit 300 into the record, as well as the corrected version of hearing exhibit 300 attachment BWE into the record. In that folder, we do have an executable as well as a red line and a clean version of both of those exhibits.
Okay, any objection to the admission of 300 corrected and BWE corrected?
No, Your Honor, no objection.
and they shall be admitted.
With that, Your Honor, Mr. Elder stands available for cross-examination.
All right, Mr. Shopkin, I guess you're first.
Thank you. Mr. Elder, my name is Greg Sopkin. I represent Black Hills Colorado Electric. It is nice to make your acquaintance.
You as well.
You work for the Coalition for Community Solar Access in Washington, D.C. That's one of the three parties that represent the joint parties in this case. Is that right?
That's correct. Our business address is in Washington, D.C. I'm actually based out of Raleigh, North Carolina.
Okay. And given your being out of state, are you familiar with Colorado's Renewable Energy Standard Adjustment, also called the RESA?
No, I do not have any significant understanding of how the RESA adjustment is calculated beyond kind of a general understanding that recovery of community solar bill credits is obtained through RESA recovery.
Okay, so is it accurate that you do agree with Black Hills witness, Mr. Ahrens, that the costs Black Hills incurs for both CSG credits paid to customers and incentives paid to CSG providers are recovered through that RESA mechanism?
Yes, I agree that those costs are recovered through the mechanism, but my understanding is further that there's some type of cap established by the commission as to the amount that customers contribute through the RESA.
Okay. Are you aware of what that cap is?
I believe it is the 2% cap that we were referencing.
Okay. And are you aware that that's a cap, not a minimum?
Yes, I understand. Yeah.
Okay. So because the cap is not a minimum, would you agree that utilities can charge less than the 2% cap amount for the RESA?
I agree with that. Yes.
Okay. And do you happen to know what percentage Black Hills Colorado Electric charges to its customers on customer bills for the RESA?
Based on the conversation earlier, I believe it is 1.5%.
Okay. All right. So if we could pull up hearing exhibit 108, please. All right, we could just scroll down a couple lines. That's good. Right there. Mr. Elder, would you agree that Black Hills served discovery requests on the joint parties, and what we're looking at right now is Black Hills discovery request JP 1-6, and that you are the sponsor of the response to that discovery?
Yes, I would agree.
Your Honor, I would seek to admit hearing exhibit 108.
Any objection to 108?
No objection.
108 shall be admitted.
And Mr. Elder, the question that was asked here is a request that the joint parties admit that the higher any adopted adjustment mechanism percentage increase is per year regarding CSGs, the higher Black Hills Colorado Electric customers are responsible to pay for CSG costs. That was the request, correct?
Yes, that's the request as I read it here.
And your response is deny customer utility bill contributions to all RESA programs are capped by the maximum RESA utility bill contribution set by the commission. Adopting a bill credit adjustment mechanism will have no impact on individual utility bills. That's your response, right?
Yes.
Okay, well, I'm allowed to ask hypotheticals. You just agreed with me that Black Hills has lowered its RISA from 2% to 1.5%. If Black Hills would like to lower that further to 1% as a hypothetical, wouldn't that reduce customer bills?
Yes, I believe that would result in a reduction to a customer bill.
And if the commission in this case proceeding decides to adopt a methodology for the CSG fixed bill credit that puts pressure on the RISA fund such that Black Hills could no longer lower the RISA from 1.5% to 1%, that would have an impact on individual utility bills, correct?
Yes, I agree with that.
Thank you. We can take this down. And if we could pull up Mr. Aaron's testimony, hearing exhibit 100 at page 13. Have you read Mr. Aaron's testimony, Mr. Elder?
I have, yes.
Okay, and this is his direct testimony. I'm looking at page 13. If we could scroll down to the bottom. Okay, right there. Beginning at line 24, Mr. Aaron states, it is worth noting that the cost to acquire renewable energy, scrolling down to the next page, credits, RECs, and energy from CSGs is by far the most expensive resource in the company's system, exceeding $100 per megawatt hour. For comparison purposes, the cost for utility scale solar identified in the company's last resource plan is $24.72 per megawatt hour, or about 1/4 of the cost of CSG. You see that?
Do you? Yes.
And you would agree, wouldn't you, that this substantial cost difference that Mr. Aaron's highlights here is the case before adding any fixed CSG CPI adjustment, correct?
Mr. Sopkin, I don't believe I addressed any of the differences in terms of resource valuation in my testimony. I can accept these numbers as presented in Mr. Aaron's testimony, but I've not conducted any analysis on the underlying studies that develop these numbers.
Okay, fair enough. If we can pull up hearing exhibit 107, please. And Mr. Elder, I will represent that what we're looking at here is Black Hills discovery request to the joint parties. This is discovery request BHCOE-JP 1-5. And if we scroll down, there were questions asked A through F, and then there is listed first a supplemental response, if we could scroll down a little further. And you can keep scrolling. And this again is sponsored by you. You're the sponsor of these discovery responses, correct?
That's correct, yes.
And to your understanding, this is actually the corrected response as of last night in light of the corrections that you just went through with your counsel based on that formula error, correct?
That is correct. Yes.
All right, so these are current discovery responses, right?
That is correct. Yes.
All right, I would seek admission of hearing exhibit 107.
Any objection to 107?
No objection.
107 shall be admitted.
And I'd like to highlight just a couple of these responses here. In part D, if we scroll up to right there, actually, let's go to the question first of part D. Question asked is, please describe with specificity how the change in price of each good and service within the basket reflects the change in cost of utility service provided by Black Hills Colorado Electric, especially where energy costs are explicitly excluded from the CPI-U. That's the question, right?
Correct.
And your response to that, moving down, begins, I'm just going to read the first sentence. The joint parties do not claim that the change in the price of each individual good or service included in the calculation of CPI is indicative of the change in cost of utility service provided by Black Hills Energy, correct?
Yes, that's the correct response.
Okay, that's the only question I'm going to ask about that. Moving down to the response to F. All right. F indicates your response to a question that, well, let's go to the question first, just to make it clear. If we could scroll up to F. Question was, please explain the percentage adjustment that would result for each year from 2018 through 2024 through adoption of the CPI-U. You see that?
Yes.
And your response, scrolling down, is the percentage adjustments for each fixed credit vintage from 2018 through 2024 through the adoption of the CPI-U is shown in the Adjusted Credit Calcs tab of 24AL-0496E, attachment BHCOE-JP1-5F corrected XLSX, correct?
Yes, that's the response.
Okay, and I'm hoping as we scroll down here, that's what we're going to see. Okay, if we keep scrolling down, and actually let's scroll down to the very bottom. Okay. I believe this should be, and you can tell me if I'm wrong, exactly what was referenced in that discovery response, which is that specific tab, the Adjusted Credit Calcs tab of attachment JP1-5F. Can we agree that that's what this is, or do you need to check?
So the file that was used in response to the discovery request was an Excel file. I have no reason to doubt that this was a PDF of that file.
Okay, and can you please tell me, looking at this document, what the far left column is, and the meaning of the word value?
So for each of these tables, the top one, for example, is what we refer to as the 2018 vintage. And the first row underneath that represents the the 2018 vintage bill credit value in calendar year 2018. And then going down the list, it would be the value of the 2018 fixed bill credit vintage in 2019 all the way through 2025.
Okay. And for each of these, like beginning with the 2018 value, when you go to the next row down, it says 2019 value. The following year always shows a 0% change, right?
That's correct, yes.
And why is that?
That is a result of the formula that the joint parties have put forth. And it's a result of the current. So if we look all the way on the right side of the screen, there is a column that says current year. And that number is referencing to, so if we take the first row here, the current year on the far right is 2017. And that is in relation to the 2018 vintage. So in 27, so let's assume that there was a fixed credit available in 2018. That value would have been proposed during the 2017 calendar year. And so the percent change that we're using as the basis of our CPI adjustment, the calendar year and the vintage year during that second year are actually the same year. So there's a 0% change between the two values.
Okay. And so when we look at this chart, other than those 0% that we see, when we look below that, you're then seeing the actual CPI-U effect, the change that would occur to the CSG fixed bill credit by using the CPI-U. Is that correct?
That's correct. So the CPI values that we're using are, as I think we detailed in our testimony, are an annualized value that doesn't necessarily align with a calendar year. And the basis for that is the timing of the advice letter submissions and the availability of CPI data. So the CPIs that we're basing our calculations on are an annualized value that references the most recent 12 months worth of CPI data that was released.
Okay, so let's just look at okay, and you'd agree when we look at each of these vintages, 2018, it goes all the way down to I think 2024, maybe even 2025. When we look at these values for each year, so looking at the 2018 vintage, let's take the year 2023. The value, if we go to the far right column, percent change, is 6.85%. And that value, if you look at the vintages below that, each time 2023 appears, you see 6.85% in that final column until at least you get to that 0% we talked about previously, right?
Yes, that's correct.
Okay, so all those values are consistent for those vintages, and you'd agree that at least from 2020 through 2025, these CPI values have fluctuated quite a bit from year to year, particularly years 23, 24, well, let's just say 2022 through 2025, correct?
Yes, I agree. There's fluctuation in those values.
And by way of the notion of predictability, there were questions asked of the staff witness about CSG providers being able to predict in future years what the credit might be. Would you agree that you have not attempted to represent what the inflation, the CPI-U values will be beyond 2025?
That's correct, because that data does not exist.
And you cannot represent that the variability that we see here from the years 2020 through 2025 is going to be any different going forward, can you?
So there will be variability from year over year, certainly. But I think it was referenced in testimony filed in this case that on average, CPI percent change or annual change has been roughly 3%. for the last several years. So when we talk about predictability, having that roughly 3% average over the, again, 20-year lifetime of a project is roughly what we're going to receive or what we can reasonably predict.
So an average roughly of 3%, but you'd agree within the last 2 years, we're showing values of 6.85, 5.82, right?
Yes, I agree. There's been some variability year over year the last couple of years.
Okay. And then, and comparing that notion with the predictability of staff's methodology, if we could pull up that chart we were looking at a bit ago, the NJB1, I think it's exhibit 400, of staff.
Is that in the testimony exhibit or was it in the attachment?
It's attachment NJB1, I believe.
Okay.
If I can be helpful, Mr. Sopkin, the executable version is in our box folder. So if that's the one you want, we should pull that one up.
I'm sorry. And if we scroll up and to the right, you'd agree that that figure NJB-1 shows the historic and forecasted credit and 5-year moving average based on staff's methodology.
Yes, with the same caveat that the staff witness had indicated that anything after 2025 is just a simulated value.
Correct. Got it. And you did not provide simulated values beyond 2025 in your analysis.
I did not, no.
Okay. And this shows, you'd agreed before 2025, the credit actually moving up and moving down with the orange dotted line.
That's correct, yes.
Whereas, and beyond 2025, the solid orange line is variable, but it's moving in both directions, right? Moving up and moving down across time.
I'm sorry, can you repeat that one more time?
When we get to the orange solid line, which is the projection, that figure shows the credit moving up and moving down in value over time.
Yes, I would agree that's what this chart is showing.
But the solid green line, again, a projection. I'm sorry, both the dotted green line and the solid green line represents the 5-year averaging, correct?
That is correct, yes.
And so when I was asking about the inflation numbers moving up and down, you said, well, you need to look at the average. And that's what staff's doing here, isn't it? Staff's applying a 5-year average to smooth it out. Isn't that correct?
Yes, they're applying an average to smooth out the variability and the bill credit value, yes.
And even though it's up and down, the general trend of the green line, at least when it's solid, shows an upward trend there, right?
I agree with you. That's what this chart shows. But again, this is a completely random data set.
Okay. And can you imagine with me, if you will, if you applied the CPI-U to this graph, the numbers that the joint parties are recommending for the fixed bill credit via the CPI-U would be considerably higher than the both the orange and green lines here?
Objection calls for speculation.
No, I don't think it does before 2025. And I could rephrase the question. Let's just
Your Honor,
go.
you're on mute, just so you know.
My dog is barking. So, I'm sorry about that. No, I think we've kind of gone into this area a little bit. We've kind of, there are a few hypotheticals out there. I think this one's fair game as well. Go ahead. You can answer the question.
Mr. Stockman, you repeat the question, please.
Yeah, I can. Let's just limit it for now for before 2025. You'd agree that the CPI-U methodology that the joint parties are proposing would result in a graph line considerably higher than the orange dotted line?
Yes, I would. However, I think that the graphs would be showing somewhat two different things, because in this graph you're showing, and what we're seeing here is figure NJB-1 is showing the bill credit, the annual bill credits, versus if we apply CPI to a fixed basis, you would essentially have multiple lines, each line referencing a different vintage of bill credit.
Okay, fair enough. Would you agree that the orange dotted line, again, that represents the annual adjusted bill credits before 2025, correct?
That's correct, yes.
And you already agreed there's up and down movement there. Would you agree with the CPI-U? There is no down, it always goes up?
Generally, yes. I mean, there could be a large deflationary period where it might, it could go down.
It would have to be a pretty dramatic economic circumstances for the CPI-U to go down, essentially a depression, right?
That's correct.
Okay. At least in recent history, that has not happened. It's always gone up.
That's a fair assessment.
And the orange dotted line represents the TAR methodology that's been approved by the commission to determine the avoided cost associated with the CSG credit, right?
That is correct, yes.
Okay. All right, we can take that down. All right, I just want to ask a couple questions about the bill credit vintages subject. And I'm going to point to your testimony hearing exhibit 300 at page 8. And I'm going to point to beginning at line 6. I'll just read it. As explained in the next section of my testimony, by omitting pre-2025 vintages, Black Hills Energy precludes CSG subscriber organizations that, one, applied for or bid capacity into Black Hills Energy CSG program prior to 2025, and two, have CSGs that are not commercially operational from having the ability to elect the fixed bill credit option, as is their right under the provisions of Rule 3881 and Section 40-2-127 CRS. That's your testimony, right?
Yes.
Okay. And you have read Mr. Aaron's rebuttal testimony in this case, right?
Yes, I have.
And you'd agree that, and I can show it to you if you want, that what he said, what Mr. Aaron says in his rebuttal testimony is no, we're not precluding that. We're just saying that if one of these CSGs has not achieved commercial operations, that instead of a prior year vintage bill credit, we would just apply the 2025 fixed bill credit. That's the company's proposition in this case. Is that right?
Yes, that's how I understand it.
Okay, and now that you understand that, is this still an issue?
I believe that by offering projects with vintages associated with 2018, 2021, and 2022, the 2025 fixed bill credit value would be inconsistent with how the fixed bill credit calculation is laid out in House Bill 23-1137, whereby it's based on the total aggregate retail rate, or TAR, at the time that the project is bid for or applied capacity into the utilities program, minus the reasonable charge also established for the period at which the project is, or the subscriber organization applies for bids capacity into the program. So in my opinion, a project that had applied for or bid capacity in 2018 into Black Hills Community Solar Garden Program should be offered the 2018 vintage and not the 2025 vintage.
Okay, and I want to understand why it doesn't help you folks to apply the 2025 fixed bill credit. If we can turn to Mr. Aaron's testimony, Exhibit 101 at page 8. Okay, and you were here, I believe, previously when Mr. Aaron's testified earlier this morning, right?
Yes.
Okay, and you heard him explain that this table DSA-2, the blue shades show the company's calculation of the CSG fixed bill credit using the TAR methodology. Is that your understanding?
Yes, that's my understanding.
Okay, and I know you folks want the CPIU, we get that, but just for purposes of my question, if the commission were to adopt the company's methodology, you'd agree that the fixed bill credit using the TAR methodology for 2025 is a greater value than previous year vintages.
In nominal terms, yes, I do.
Okay.
However,
I'm sorry, go ahead.
So if we take 2018 vintage as an example here, we see that in 2018, the 2018 bill credit value was 0.1079. And after applying an escalation, what that value would adjust to in year 2024 is 0.1342, which is 1 cent greater than what the 2024 blue cell would be of 1242.
Okay, and so what you're saying is if you have a project that is not yet completed, the bid was put in 2018, then for that project, even though it doesn't become doesn't achieve commercial operation until say 2025, you would need to inflate that number here for 2018, the 0.1079 across all those years using the CPIU, which shows again in 2024 the 0.1434 number, right? Or no, 1.1342 number.
Yes, I believe applying the adjustment mechanism in our case, as the joint parties are proposing with the CPIU, that adjustment would allow a CSG customer to realize the change in value of the fixed bill credit over time, which is, from my understanding, the entire purpose of the adjustment mechanism.
So never ask a why question, but why should a CSG facility that has not achieved commercial operation until 2025 get the benefit of the CPIU for 1, 2, 3, 4, 5, 6 years?
As set forth in HB 23-1137, the calculation of the fixed bill credit should be based upon the inputs being the TAR and the fixed reasonable charge at the time that the project was bid into the utilities program. That is, just staying in alignment with the letter of the statute.
Okay, so your answer relies on the letter of the statute. It's not really an economic explanation, correct?
That's correct.
Okay. Your Honor, I have no further questions.
All right. And Mr. Horman, I see you on my screen, so at least I see your name. So I'm guessing you're going next.
No, Judge, Jennifer Hayden will be.
What? You suddenly turned into Jennifer Hayden. Okay. All right, Ed.
Thank you. Let's see. Good morning, Mr. Elder. My name's Jennifer Hayden. I'm an Assistant Attorney General representing trial staff of the PUC.
Good morning.
Good morning. Good to see you. Just a couple questions. Mr. Elder, you had previously testified that the joint parties are not challenging the bill credit values proposed in the advice letter. Is that right?
That is correct, yes.
And that the joint parties are not seeking to make any changes to the fundamental methodology used to calculate the CSG bill credits.
That's correct. We're not challenging the underlying methodology.
Okay. You're here advocating for the commission to adopt those fixed bill credits for vintages prior to the date of House Bill 23-1137. Is that right?
Yes, we're advocating that the advice letter be updated to include vintages for 2018, 2021, and 2022, which all predate the enactment of HB 23-1137.
To go back 5 years prior to the enactment of that legislation.
Yes, in my reading of that bill, there is no limit on the earliest vintage or restriction on the earliest vintage, which should be able to take advantage of the fixed bill credit election. The only, in my understanding of both the legislation and Rule 3881B, the only limitation is whether or not the project has become commercially operational or not.
Did you read anything specific in the legislation that it should be applied retroactively?
There's no explicit reference on when the earliest vintage would be able to take advantage of the fixed bill credit, but there's also neither restriction listed in the legislation either.
And you're seeking to have it applied not to every year, but just 2018, 2021, and 2022, is that right?
That's correct. And the basis for those recommendations are based off of Black Hill's publicly available CSG development data. So those vintages or those years are associated with projects that have yet to reach commercial operation but have applied for Black Hill's program.
Okay, thank you. The joint parties believe that the CPIU population group is the appropriate attribute for the population component of the CPI index and the one that was used in your methodology. Is that right?
That's correct, the CPIU.
It's the broadest measure, I think, right, that you'd said?
That's correct. I think in my testimony, it represents, or according to the Bureau of Labor Statistics, it accounts for roughly 90% of the general population, that segment.
And the one that's most widely used.
That's correct, yes.
Is there a consumer price index for energy?
There is a utility cost CPI value that's involved with the expenditure items. That there is a CPIU for energy. That's correct, yes.
But that wasn't the one used here. Rather, the joint parties elected the CPIU, the one that specifically omits energy. Do I have that right?
Yes, the series that we used. There's several different components to it, but yes, I believe the component that you're referring to is the all items minus food and energy, I believe is what it's referring to. And the purpose for that is, as the BLS, the Bureau of Labor Statistics, had shown in some of its information, those categories are often the most volatile in terms of price changes over time. And the all items minus food and energy is also similar to the CPU versus the CPUW or CPIW rather, is the more commonly used series for applying an adjustment factor.
Does staff's proposal reduce the volatility you just mentioned?
Yes, I would agree that the 5-year averaging concept implemented in staff's proposal would reduce volatility over time.
Thank you, Mr. Elder. Your Honor, staff has no further questions for this witness.
Okay, I only had a couple. Ms. Hayden just asked one of them right there. I was going to ask you, because I'm not sure about this. Your CPI, I'm pretty sure I know the answer, but that adjusts every year, correct?
Yeah, so for the specific data set that we're proposing, which is a metro specific to the Denver, Aurora, Lakewood metropolitan area, is actually calculated bi-monthly. So it's released by the Bureau of Labor Statistics on every odd numbered month.
Okay. But each year, the adjustment would be made each year, and it would, as opposed to a 5-year average.
That's correct. So what we're proposing in our testimony would be an annualized value based on the last 12 months.
So let's say some crazy hypothetical that could never happen. Like someone gets in office and they put enormous tariffs on everybody in the entire world, and the economy goes all nuts. That could make the going for 1 year in much more than a 5-year average could change it up more, correct?
Yes, if I understand your question correctly, you would see that volatility more apparently in a 1-year average versus a 5-year average.
Okay. Second thing I want to get to is Mr. Sopkin, and we don't have to bring this up. Actually, the part that Mr. Sopkin brought up in your testimony, if you would have kept going, the part that interested me was you said the plain reading of both of these authorities indicates that it should go back, the vintages should go back, which plain language in the legal world has a lot of definite meaning. Okay, so when I have to read through statutes, I have to read through rules, and I look for plain language. I'm looking for plain language. Part of the testimony you just gave to Ms. Hayden seemed to say that the reason why you think it could go back is because it didn't say that it couldn't. Is that correct?
That's a fair assessment, yes.
So there's no plain language saying it should. Is that correct?
Yes, there's no language saying it should, and there's no language on the flip side of that coin saying there shouldn't.
Right. So that's why the plain language statement in your testimony kind of threw me a little bit there. So let's see. Okay, I think that's all I have. Screecher, you can do any redirect you got.
Just a few questions here for Mr. Elder. So, Mr. Elder, do you recall when Mr. Sopkin was asking you a hypothetical about the RISA account and the impact of applying a consumer price index adjustment to the fixed bill credits?
Yes, I do.
First of all, do you agree with me that it's the incremental value of the bill credits that's recovered through the RISA, not the entire value of the bill credit?
Yes.
And do you have any reason to believe that if the commission were to apply the joint parties' recommendation to, have a CPI adjustment to the fixed bill credit, that Black Hills would need to increase the RISA percentage it charges to customers?
No, I would not.
And to your knowledge, has Black Hills provided an analysis on the record here showing that the RISA would need to be increased for customers if CPI is applied to the bill credits?
No, not to my knowledge.
Okay. another area, do you recall when Mr. Sopkin and Ms. Hayden were asking you about 2018 vintage community solar garden?
Yes.
That line of questions. Why are there so many community solar gardens from the past that have not yet reached commercial operation?
So I think in general, I'm not necessarily familiar with the exact projects that are involved in the 2018 vintage, but there can be any number of reasons why a project has been delayed extensively. For example, since the 2018 vintage, generally there can be significant delays with the interconnection process that goes all the way from the kind of pre-development study process, how that project is studied by the utility, going through, once it is studied and once it's determined that there might be system upgrades that need to be constructed prior to the interconnection of that facility. The design of those projects and the construction of those projects can require a significant amount of time before a project is able to interconnect in the distribution system.
And with those delays, is it possible that the cost to construct that project goes up if there's been, inflationary forces over time?
Yes,
I'm going to object that this is speculation. The witness already said he has no idea what has happened with these projects. He has no specific knowledge of these projects. This is speculation.
Richard?
I think you already answered the question and was able to answer the question, so I'd have the record stand as is.
I guess we've had a lot of speculation of a whole bunch of things here, and this is kind of looking into the future and all that.
Okay, just a couple additional redirect questions, Mr. Elder. So you just had a lot of questions about the consumer price index that was put forward by the joint parties in this case. Ms. Hayden just asked you about whether or not we could have proposed an energy specific index. Do you recall that question?
I do, yes.
Is the CPI-U index that you've proposed the same index that's used by the commission in other regulatory contexts?
Yes, I believe it is. As we saw earlier, there was a reference to it in the Black Hills Electric Tariff book, and I believe there's also a requirement that the commission escalate interconnection payments or interconnection penalties rather based upon an adjustment of CPI.
Great. Were you online when Mr. Ahrens testified about his CPI calculations in his rebuttal testimony?
I was, yes.
Can you explain the key differences between your calculation and the Black Hills calculation put forward in Mr. Ahrens' testimony?
Yes, so in Mr. Ahrens' testimony, and the table we've been looking at in his rebuttal, I believe, he's using the calendar year change in CPI. Again, going back to the timing issue of when the utilities advice letter filings that must set out the fixed bill credit values for the prior year need to be filed by that November 15th deadline. The full calendar year CPI data will not be available at that time, given the delay and when it's released. So the difference between Mr. Ahrens' use of CPI and mine is again based upon which CPI values are being calculated or being used rather. So again, the joint party's proposal is using the most recent 12 months worth of CPI data that is available at the time in which the advice letter filings are being submitted.
So just to clarify that mechanically, there may be a problem with implementing the Black Hills calculations because of this annual value, whereas you've accounted for that by looking at the prior 12 months. Is that accurate?
That's correct. The data involved in the Black Hills proposal will not exist when it's necessary for the advice letter filings to be filed.
Let's level set here the reason for this conversation. So you've gotten a lot of questions here about CPI. isn't it accurate that the joint parties suggested a CPI adjustment to account for the change in the value of the dollar over time?
I'm just going to object to the leading nature of this. I've bit my tongue for the last few, but this sounds like Ms. Coutser testifying, not Mr. Elder.
You want to rephrase? I mean, this world has a lot of leading questions all the way through. Sometimes just for the sake of speed, but Ms. Coutser, why don't you just
I'll reframe.
rephrase it a little bit.
Why did the joint parties propose a CPI adjustment mechanism in this case?
So the use of CPI, I think, is a commonly accepted indicator of inflation, the impact of inflation. And when we're looking at an adjustment mechanism that's required by HB 23-1137, which would allow a CSG subscriber to recognize the change in value of their fixed bill credit over time, the use of CPI is a transparent and a reasonable mechanism to effectuate that requirement.
And would a CSG subscriber, particularly a low income subscriber, be sensitive to the buying power of a dollar decreasing over time?
Yeah, absolutely. The change in the purchasing power of a dollar, I think, was impact any one subscriber or not.
And if properly constructed, would a fixed bill credit with an adjustment mechanism provide certainty for customers?
Yes. So again, going back to kind of the average change in CPI over time, hitting that roughly 3%, if a customer is able to keep in mind that the value of their bill credit will be changing roughly 3% every year, that would provide a source of predictability and certainty about the value that they can expect over the lifetime of their subscription.
Last question, Mr. Elder. Would the joint parties be open to a 5-year average of the consumer price index if ordered by the commission?
I think we would be open to that, yes.
That's all I have. Thank you, Your Honor.
Right. And I'm going to ask one real quick one, so you might have another one. So do you believe I'm required to make this adjustment in this case? I meant to ask you that.
So with respect to the 2025 vintage, I think, yes, there's a requirement that you should consider the change in value of the 2025 vintage to CSG subscribers over time. Because in referencing back to the decision C240447, I believe there's the term used, fixed is fixed, after the fixed bill credit is set. And that's the purpose of this proceeding here today, is to establish the 2025 credits, as well as what we're requesting for the 2018, 2021, and 2022 projects as well. And so once those fixed bill credits are established in this proceeding, after it's disposed of, there will not be another opportunity for us to come back and revisit any adjustment to those mechanisms or to those bill credit values.
All right, so I have to do it in this proceeding.
That's my understanding of the decision, yes.
Do you have anything off of those questions? Go ahead.
No, thank you, Your Honor.
All righty. Real quickly, all the hearing testimonies is admitted. I also have 302 corrected, 300, and BWE 108 and 107. So if there's something else that you think should have been admitted, tell me now. But I don't think there's anything else. Mr. Saab, can you have anything more?
No, for what it's worth, I bought Giardina last weekend at the West Colfax Chicago restaurant so I could make Pope Leo sandwiches this weekend.
It's exactly the Pope Leo sandwich from Portillo's has the Giardina. Oh, exactly. There's supposed to be one that's going to be like maybe a mile and a half from my house. I check every 3 months to see if the Portillo's is going to be there. But I'm very excited about that. They put a White Castle. They need to put a White Castle right next door to it, and I'm in heaven. Okay, first up, and real quickly, thank you to all the parties. You did a great job. This was a limited case. I'm glad we didn't start going off into directions. You guys did a great job of keeping it all together there, and I truly do appreciate that. My hope was we'd be done by noon, and it's 12:06. So, I sometimes proceedings go off in directions they don't need to. This one did not, and I do appreciate that. Mr. Shopton, other than wanting to give me an Italian beef sandwich, you need anything else?
I'm trying to remember when statements of position are due.
They're not, that's always, actually, I gotta figure that out. That's what we gotta figure out. Because you guys had like some really crazy one, and with the other case that's going on, I know, Mr. Shopton, you will not be here to join us when we all get together again in 2 weeks to do a very, very similar hearing. But I didn't know, I figured now would be the time to figure that out. So,
Your Honor, may staff
Okay.
make a suggestion on that point?
sure.
We would like to suggest that the commission consider implementing the June 12th date. It's the date set in the follow-up Pisco case for the SOP to be due. Is that a viable date, June 12th, so that both SOPs would be due on the same day?
And I don't think Mr. Sopkin cares, but it's Mr. Kreutzer, because she's gonna care. So what do you tell me? What do you think?
Yeah, fundamentally don't object to that. However, it does fall right in the middle of the Fiasco just transition case. So juggling two SOPs in that time frame is not totally ideal. I guess I'm probably gonna write it ahead of time anyway. So I could have it earlier, but if that's what staff wants, I'll just sit on it and file it on the 12th.
Well, sooner you get it, the better for me too. Or sooner I get it, the better for me. And I'm gonna be on vacation the first week of July. So I tell you what. About the 10th. How about the 10th? Give a couple days in there for that. Ms. Hayden, what do you think?
That's agreeable, Your Honor.
That works.
Okay, we'll make it June 10th. So SOPs are due June 10th. Because I got a feeling there's going to be a lot of things that are similar in both of them. So since the issues are essentially the same. So okay, get that figured out. Mr. Sopkins, getting me a sandwich. Anything else?
That's it, Your Honor.
Ms. Hayden?
No, thank you, Your Honor.
Mr. Harmon, who rejoins us, you got anything?
Nothing for me, Your Honor. Thanks.
Ms. Kurtzer, you're the last one.
Nothing for me. Thank you, Your Honor.
All right. Thank you once again. Thank you, everyone. Thank all your witnesses for me again. I do appreciate them being here. We appreciate the time they did. Mr. Elder, I don't think I said that to Mr. Elder. I'm sorry, Mr. Elder. Apologies. Thank you very much for being here. And we'll get that out. Everyone have a great weekend. That's it.
You
You
too.
too.
Thank you.
Thank you.
Bye.